Okay, Mr. Trump, do you understand why you're in court today?
No, I forgot.
The issue surrounding the $2 million severance deal of the former chief financial officer of the Trump Organization, Alan Weisselberg, has been brought to light by an analyst. In response to Weisselberg's testimony during ex-President Donald Trump's New York civil fraud trial on Tuesday, MSNBC legal analyst Lisa Rubin utilized X, formerly Twitter, to share her insights on Weisselberg's severance agreement. According to PBS, the lawsuit filed by New York Attorney General Letitia James alleges that Weisselberg manipulated Trump's financial statements to fulfill his demands for increased net worth and approved inflated valuations for assets despite contradictory appraisals. Before we get started, be sure to subscribe and hit the notification button to be notified when we post great videos. Let us know your possible suggestions by leaving your comments below. On Wednesday, Rubin reported that Alan Weisselberg's severance agreement will ultimately compensate him with $2 million by December 31, 2024, provided that he fully complies with the terms. Rubin noted that the agreement includes a provision that is not uncommon, which requires an employee to promise not to assist with others' claims. However, Rubin expressed concern about the context and timing of the agreement. Specifically, Weisselberg left the company at the end of 2022, and the agreement required him to complete his work in good faith before that date. Nevertheless, Weisselberg did not execute the agreement until the literal eve of his January 10, 2023 sentencing. Furthermore, the agreement was not signed by Alan Garton, the Trump Organization's chief legal officer, until January 12, 2 days after Weisselberg entered Rikers. Rubin further stated that, in addition to the aforementioned details, as outlined in the attached payment schedule of the agreement, the Trump Organization did not commence remunerating him until March 31, 2023. This date falls considerably after his incarceration had begun, and notably subsequent to reports indicating that the Manhattan District Attorney's Office was still actively investigating Weisselberg for insurance fraud. Now let us redirect our attention to the severance obligations imposed upon him. These obligations encompass his cooperation in any investigation or legal proceedings involving the company or individuals associated with the Trumps. This cooperation entails engaging in meetings with them pertaining to matters of discovery or pretrial issues, as well as providing truthful testimony on behalf of the releasees. Consequently, it can be inferred that he was likely required to meet with them prior to his trial testimony. She continued, the severance agreement also includes provisions for indemnifying Weisselberg's reasonable attorney's fees in the event of any legal matter involving him or the company. However, there are significant conditions attached to this provision. He is not permitted to engage legal representation without obtaining prior approval from the company. Furthermore, the company reserves the right to jointly represent Weisselberg with its own counsel, provided there is no direct conflict of interest and at the company's discretion. In other words, if he wishes to have his legal fees covered, the company has the authority to determine his legal representation and even impose their lawyers on him. Nevertheless, these conditions are overshadowed by Weisselberg's commitment to refrain from disclosing information to any party with claims against the company and our individuals he has released, such as Trump, unless compelled by a sub alia or court order. Additionally, he is prohibited from taking any action that may induce, encourage, instigate, aid, abet, or otherwise prompt any person or entity to initiate a complaint, charge, lawsuit, or any other form of legal proceeding against the company or any individual or entity released under this agreement. In his analysis, Rubin asserts that the agreement effectively prohibits Weisselberg from willingly collaborating with any law enforcement or prosecutorial agency in return for leniency regarding potential investigations or charges related to other crimes. This provision may be deemed unenforceable due to its conflict with public policy. However, from Weisselberg's perspective, there is no motivation to challenge this notion, considering the substantial severance package of $2 million that he stands to receive, even in the event of his demise. In conclusion, there appears to be no incentive for Weisselberg to take any action. That's what we have for you today. What do you think of our video? Let us know in the comments section below, and don't forget to subscribe, like and hit that share button.